U.S. Supreme Court justices on Thursday heard arguments on whether former President Donald Trump should be kicked off the ballot in Colorado over his actions on January 6, 2021, when his supporters attacked the U.S. Capitol. The justices took up the case after Colorado's top court sided with a group of voters who sought to remove Trump from the state's Republican primary ballot under the U.S. Constitution's 14th Amendment. Section 3 of that amendment bars from public office any, quote, officer of the United States who took an oath, quote, to support the Constitution of the United States and then, quote, engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof.
None of these criteria were met. This was a riot. It was not an insurrection.
Trump attorney Jonathan Mitchell argued that Section 3 did not apply to the former president, saying he was not an officer of the United States. He also argued that states cannot enforce Section 3 and that the events of January 6th did not amount to insurrection. On that day, Trump supporters attacked police and swarmed the Capitol in a bid to prevent Congress from certifying President Joe Biden's victory. Trump gave an incendiary speech to supporters beforehand, telling them to go to the Capitol and, quote, fight like hell. He then, for hours, rebuffed requests that he urged the mob to stop. Trump's attorney said the day's chaos did not meet the standard to disqualify him.
The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used in Section 3.
The attorney representing Colorado voters seeking to disqualify Trump argued the opposite.
We are here because for the first time since the War of 1812, our nation's capital came under violent assault.
Attorney Jason Murray said that Trump, by egging on his supporters with false claims of electoral fraud, fueled their attempt to disrupt the certification of his 2020 loss.
By engaging in insurrection against the Constitution, President Trump disqualified himself from public office.
The justices spent a considerable amount of time mulling the proper way that states may enforce Section 3 against candidates, primarily focusing on whether Congress must first pass legislation. Conservative Justice Brett Kavanaugh suggested an opinion by a 19th century Chief Justice had largely put the onus on Congress, not the courts, to determine who was qualified and who wasn't.
The branches of the government have acted under that settled understanding for 155 years, and Congress can change that.
Both conservative and liberal justices balked at the potential ramifications of allowing states the leeway to disqualify presidential candidates, giving them the power to remove choice from voters. The attorney for Colorado had this blunt reply.
The reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't require that he be given another chance.
From his home in Mar-a-Lago, Trump expressed confidence in the outcome of the case.
I listened today, and I thought our arguments were very, very strong.
The case calls on the Supreme Court to play a central role in a presidential contest unlike any since its landmark Bush v. Gore decision that handed Republican George W. Bush the presidency over Democrat Al Gore in 2000. And Tuesday's case may not be the only one involving Trump's actions on January 6th, likely headed for the Supreme Court. The ex-president is facing criminal charges over a number of alleged schemes to stay in office after his election defeat. The justices may soon weigh Trump's claim that his actions as president render him immune from prosecution.